यहाँ पे रिपोर्ट मांगी गई थी कि वो किन सर्कमस्टांसेस में हुई है, वो रिपोर्ट आई है अभी तक? वो रिपोर्ट ही नहीं आई अभी तक।
सर दैट्स अ डिफरेंट क्वेश्चन। मेरा इसमें मैंने तो आर्ग्यू किया है, वो आप कहें मैंने नहीं आर्ग्यू किया।
मानी बताइए, एंट्री 55 का जरा मानी बता दें, हाउ यू अंडरस्टैंड एंट्री 55?
This relates to jurisdiction and powers of all the courts except the Supreme Court with respect to any matters in this list and to such extent as is expressly authorized. So it has to be expressly authorized by or under the Constitution.
क्या माने?
इसका मतलब है कि Constitution उसको authorize specially करेगा तो वो चीज़ आएगी।
तो by हो गया ना, under the Constitution का क्या मतलब?
Sir, which is by or under means कि
are you interchangeable words and under doesn't add anything? Is that what you're saying?
No, sir.
They can take this question with a level of seriousness. Don't just sort of flip-flop the question like that. It's a very important case. You give it the, you just agreeing, disagreeing. My lord has asked a very specific question, and under what does it add? Say nothing, say something, what does it add?
Sir, by or under the Constitution means that anything which is either provided by the Constitution or under the Constitution, which would your lordship would deduce through an interpretation.
Are they interchangeable terms?
Included in that. Because by the Constitution means that it has to be included in the Constitution.
Whether it is expressly provided in the Constitution or by implication provided by the Constitution, but there is a question here.
No.
You see, enlargement.
But it
आप
relates
जवाब तो
to
देना पहले सवाल।
सर उसका
देखिए आपसे पूछा है ना, बाय और अंडर क्या? अंडर बाय द पार्लियामेंट है, बाय द एक्ट ऑफ द पार्लियामेंट है, अंडर द कॉन्स्टिट्यूशन। अंडर द कॉन्स्टिट्यूशन से क्या मानी, कोई रेफरेंस दे ना।
Under the Constitution which is provided, and in the Constitution would include everything and anything which is in there.
Mr. Hassan,
would
you're
be
not
a power to make
Hassan
legislation.
साहब, you're not adding anything useful.
Sir, मैं बस conclude
फिर आप इसको
एक
conclude ही
चीज
कर रहे हैं।
सिर्फ बता दें, enlargement of jurisdiction. One, enlargement, the word enlargement in itself implies that something already exists and it is being enlarged. Now, providing a fresh appeal is conferring a jurisdiction or enlarging a jurisdiction?
It's conferring the jurisdiction. It's not enlargement. It is not.
Why?
Because it does not exist previously. So anything which maybe enlargement would be which is already existing and your lordships are given additional powers to do that, or
Can you cite an example? Cite an example.
Learned Council, ये अपील जो है, ये अपील किस jurisdiction और power की remedy है?
Sorry?
किस power और jurisdiction की remedy है? The appeal 143 की है. That power already exists.
Sir,
And it's only a continuation of the same power.
Sir, 185 के अंदर 184 की appeal does not exist with utmost respect.
Learned Council जो my lord ने सवाल पूछा
वो
है,
सवाल के ऊपर
कि
again
देखिए ना,
देखिए
दो-
question ये है
सवाल
कि
ये
if
है,
your lordships are to
सवाल ये
read
है,
into the
सुन,
Constitution, then that's a
Council,
different
The
question.
question is, 184 is before 185. ठीक है? सारी जो अपील्स सुप्रीम कोर्ट के में प्रोवाइडेड हैं वो हर उसकी तमाम सूरतें 185 में मेंशन की गई. If the framers of the Constitution wished to provide an appeal under 184, they could have easily added something in 185 saying 185 के अंडर 184 के ऑर्डर्स के अगेंस्ट अपील हो सकती है. आर्टिकल आइटम 55 में enlargement के वर्ड इस्तेमाल करके ये कहना कि जी हम एक नई jurisdiction create या confer कर सकते हैं, is that doable?
और उसी में मैं ऐड कर दूं कि कंपटीशन कमीशन एक्ट में अगर अपील है और काफी कवानीन है जिसमें सुप्रीम कोर्ट में अपील आ गई, तो फिर वो तो एक्सप्रेसली कॉन्स्टिट्यूशन में नहीं दी हुई जुरिसडिक्शन लार्ज
सर
वो कैसे फिर अपील आ
गई?
गई?
we are trying to mix the two things. That is by virtue of another entry in the Constitution, the legislation relating to that has got nothing to do with 184 power.
जी मैं वही आपसे पूछा, एंट्री 55 में स्पेसिफिकली enlargement of jurisdiction डील करती है, तो we will not go to any general entry, we'll go to the specific entry first, which says that enlargement jurisdiction can be either expressly given in the Constitution और अंडर तो का मतलब ही नहीं अभी तक आपसे आया, लेकिन चलें बाय द कॉन्स्टिट्यूशन एक्सप्रेसली, तो फिर कंपटीशन कमीशन की अपील कैसे आ गई?
सर उसमें जो अपील जी सर 185 को जब आप पढ़ेंगे 185 के अंदर अपील
कंपटीशन कमीशन के
हसन साहब, यू नॉट रियली आंसरिंग एनीथिंग. नो यू आर नॉट आंसरिंग, सॉरी टू से. तो आप किसी और को दे देना, अब काफी हो गया ना. अब देखें एक बच्चे, अब आप कितना, आपने आधा घंटा 20 मिनट आधा घंटा कहा था, हमने आपको 2 घंटे दे दिए हैं.
सर मैं एक मिसाल देता हूँ आपको. आप एग्जाम्पल की बात हो रही है, देखिए मैं लास्ट डेट पे भी मैंने एक क्वेश्चन किया, उसका जवाब नहीं आया. इसे आपके लॉ रिफॉर्म्स ऑर्डिनेंस 1972 के तहत एक कॉन्स्टिट्यूशनल प्रोविजन जो 199 है, उसके लिए एक अपील प्रोवाइड की गई है. उस अपील को बाद में 269 आर्टिकल 269 में उस जो आपके ऑर्डिनेंस था, मार्शल लॉ ऑर्डिनेंस, उसको कॉन्स्टिट्यूशनल कवर दिया गया कि ये जो ऑर्डिनेंस के तहत एक अपील की रेमेडी दी गई है वो दुरुस्त दी गई है. वो भी कॉन्स्टिट्यूशन, वो कि वो हाई कोर्ट से मुताल्लिक है, नो डाउट, लेकिन हाई कोर्ट को भी 202 कंट्रोल कर रहा है, सुप्रीम कोर्ट को 191 कर रहे हैं, दोनों से. अगर 199 में अपील की रेमेडी आज तक चली आ रही है, क्यों ना 184(3) में आप कैसे कह सकते हैं कि ये नहीं होनी चाहिए? वहाँ होनी चाहिए बेशक हाई कोर्ट से.
फिर वो सिविल प्रोसीजर कोर्ट की अमेंडमेंट के थ्रू अपील है, दैट इज अ डिफरेंट कॉनोटेशन. हियर इट्स अ कॉन्स्टिट्यूशनल प्रोविजन, इट्स अ डिफरेंट कॉनोटेशन. वो तो हम उसको दो चीजों को इंटरलिंक नहीं कर सकते.
और आइटम 55 में हाई कोर्ट के मुतालिक लेजिस्लेशन का कदगन नहीं है,
कोई भी नहीं है.
Yes, Mr. Bandari, I think you want to now take the rostrum.
I have a question. I have a question. ये जो आपसे enlargement of jurisdiction पूछा था, I go back to the question कि जो constitution of benches है, वो कौन सी jurisdiction है under the constitution जिसको enlarge किया जा रहा है?
कोई भी नहीं है. वो तो आपने constitution of benches में बनाई है, कॉन्स्टिट्यूशन में तो कोई प्रोविजन नहीं है. That's just the whole.
That's not an enlargement of jurisdiction, or is it a jurisdiction?
That is all. In fact, that is a jurisdiction. That's not an enlargement of jurisdiction. Constitution of benches are by way of the rule-making part that the court has decided that benches is formed.
So that's not an exercise of jurisdiction.
England के अंदर they have actually formed a special law for that.
कि ऐसी ज़बानी बात ना करें, लॉ का हवाला दिए.
सर
इंग्लैंड में ऐसे लॉ हो गया, ऐसे नहीं करें ना, दें चीजें हमें. फिर
मिस्टर हसन, इस लॉ में दो चीजें हो रही है ना, एक प्रैक्टिस एंड प्रोसीजर है, एक अपील की जुरिस्डिक्शन की बात है, तो दो मुख्तलिफ चीजें हैं, इसको सेपरेट रखें.
बिल्कुल सेपरेट करें.
ख्याल में बंदारी साहब शायद बेहतर जवाब दें, शायद या सुनते हैं इनको.
जी सर, बिल्कुल. थैंक यू वेरी मच फॉर.
थैंक यू. You are a petitioner?
My lord, I am representing PTI, your lordship.
Are you a petition number?
My lord, notice was issued in all petitions.
Have you filed something?
My lord, I filed two concise statements, CMA 3933
3933
and CMA number 8351.
8351. What are the difference between the two?
My lord, the first was filed several months ago. The 8351 was filed yesterday in the light of the observations that have been made on the last date of hearing, the submissions made by counsel. I've tried to address some of the points that have come up during your lordship's observation.
No, first of all, tell me where you stand.
My lord, I am under instructions to support the petitioners, but with some caveats. I am not saying, and I'll just say this and then move on to my submissions. Well, I am not saying that the Parliament cannot per se make any law as far as the practice and procedure of the Supreme Court is concerned. It can, but that power is heavily circumscribed by various express and structural limitations within the Constitution. So that's heavily circumscribed. But within those limits, it can, and I'll expand on that. So, as my Lord Justice Mansoor just said, there are two aspects to the.
First, finish your thing.
My Lord.
Then you come to what we have observed.
My Lord, yes.
You are conceding that the Parliament can, but their powers heavily circumscribed.
Heavily circumscribed.
Now, which particular provisions of this Act you think the Parliament has exceeded its jurisdiction?
If I may, if you could first expound on your initial proposition. Sorry, as far as the first point, if you could expound on that particular part. That that the legislature has the power. Explain that. Then move on to the issue where the restrictions are.
My Lord, absolutely, that's exactly how I will address. And I will address both aspects of the law on this point. First aspect is the practice and procedure aspect, sections 2, 3, 4, 6, 7. And then there is the appeal, and I'll address them separately. I'll start with the practice and procedure bit first. My Lord, the various articles have been read out before the court many times. My Lord, Article 1, let's start off with where the Parliament draws its legislative power from. There are two sources in the Constitution. One is Article 142, which takes us to the federal legislative list. The second are a set of provisions in the body of the Constitution which confer specific power on the Parliament to make laws on identified specific subjects. These are the two sources. Now, the question before your Lordship and your Ladyship, the question before the court is, as has come out in discussion recently, is whether Article 191 by itself, and I emphasize upon the word, my Lord, by itself, is a source of legislative power. And my submission on that is that it is not. And I'll explain the reasons why I say that. My Lord, your Lordship has already seen the preamble to the preamble itself identifies the source of legislative power that the Parliament has invoked. It has invoked two sections, two articles, Article 175(2) and Article 191(2). My Lord, let's just read both of them very quickly and then compare their language to Article 142. Article 175, Clause 2 says this: no court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by or under any law. This is similar to, but slightly more specific than 191. 191 says, subject to this constitutional law, the Supreme Court may make rules regulating the practice and procedure of the court. Now your Lordship may turn to 142. 142 is cast in different language altogether. It starts off by saying, subject to the Constitution, A, Majlis-e-Shura Parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. So the legislative power is conferred with respect to identified subjects.
Subject to
Subject to the Constitution. And the appropriate legislature is identified. So that's how, in my humble opinion, you identify whether an article is a source of legislative power. It identifies the subject on which the legislature can enact law, and it identifies the legislature itself. Now, if your Lordships go back to 175(2), it simply says, no court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by any law. It doesn't say what is the...
Clarify for me. You are saying Parliament does not have power to legislate except items mentioned in the federal legislative list. Is this what you are saying?
My Lord, what is mentioned in the federal legislative
Yes or
list?
no?
Yes, and also on what is mentioned in the body of the Constitution. And I'll just take your
Okay, now I will give you an example. My reading of the fourth schedule, I mean, science is developing, artificial intelligence has evolved. Urdu में इसको शायद मसनूई ज़हानत कह लें, outer space, खलाई बसीत कह लें शायद, सोशल मीडिया, समाजी राब्ता कह लें, तो इनके मुतालिक पार्लियामान कानून नहीं बना सकती है क्योंकि इन तीनों चीज़ों में से एक का भी जिक्र फेडरल लेजिस्लेटिव लिस्ट में भी नहीं है और आइन की किसी शिक में एक्सप्रेसली या इम्प्लाइडली भी नहीं है. अब आप अटेंड कर लें मेरे सवाल को।
माय लॉर्ड, मेरे ख्याल में बना सकती है।
भी तो आपने अपना ही सवाल को तोड़ दिया फिर अपने जवाब को।
नो माय लॉर्ड, मैं आपने जो लेजिस्लेटिव लिस्ट में एंट्रीज हैं उनको टू द मैक्सिमम पॉसिबल एक्सटेंट,
मैंने 3 एग्जांपल दे दी ना, इनको किसी तरह से भी वहां नहीं फिट हो रही हैं और ना आइन की किसी और शिक में आ रही हैं ये बातें जो मैंने आपसे जिक्र की हैं। तो फिर पार्लियामान के पास तो इख्तियार नहीं है ना, पाकिस्तान स्पेस प्रोग्राम नहीं शुरू कर सकेगा क्योंकि फेडरल लेजिस्लेटिव लिस्ट में इसका तस्करा नहीं है। या तो आप ये आर्ग्यूमेंट करेंगे कि नहीं सिंध कर सकता है, वफाक नहीं कर सकता है, क्योंकि बाकी सारे इख्तियारात फिर सूबों के पास हैं।
That's not
ये तो आप जवाब दे देना।
मैं दे देता हूँ।
ऐसे ब्रॉड आप अगर पेंट ब्रश स्ट्रोक्स लगाएंगे तो उसके लिए अपनी मुश्किलात भी खड़ी हो जाती हैं।
Let me explain. For example, with respect to space programs, if Pakistan has entered international treaties,
हम कानून की बात कर रहे हैं, कानून
then there are specific entries which allow Parliament to enact law for implementing international
कौन सा एंट्री है बता दें?
Well, entry 3. Entry 3, external affairs, implementation of treaties. For example,
आप इसको सुन तो लीजिए ना, ऐसे ना करें ना, थोड़ी सी हमारी भी कदर कर लें। एंट्री 3 को ट्रीटीज की तो मैंने बात ही नहीं आपसे की। आप सुन भी लेना, ट्रीटी की मैंने बात ही नहीं की। मैं तो आपको कह रहा हूँ पाकिस्तान चले ट्रीटी से खिलाफ ही कर रहा है काम। ट्रीटीज में क्यों जोड़ रहे हैं हम? भाई किसी को आउटर स्पेस में प्रोग्राम करना है, इंडिया ने क्या कोई ट्रीटी के जरिए कर रही है? अगर हम कल शुरू करना चाहें तो आपके मुताबिक हम नहीं कर सकते हैं, या कर सकते हैं तो अगर कर सकते हैं तो वो कौन सा पावर पार्लियामान इस्तेमाल करेगा?
माय लॉर्ड, लेजिस्लेटिव एंट्रीज में बहुत सी
बता देना मुझे एक।
फॉर एग्जांपल माय लॉर्ड, जैसे ये अगर इसमें ये न्यूक्लियर एनर्जी का
न्यूक्लियर की बात अलग है,
उसके अंदर माय लॉर्ड आपने मकल्लफ वर्सेस मेरीलैंड का केस आपने
आप लोग इतने मुतासिर हो गए हैं अमेरिकन, हम आपसे हमारा रिटन आइन है उसकी हम बात कर रहे हैं, उनका आइन अपनी जगह है।
मैं आपकी जजमेंट जो कि आपने
भाई अब जजमेंट को छोड़ दीजिए ना,
सिविल एविएशन अथॉरिटी के केस में दी, उसमें आपने
आप जरा ना तसल्ली से बहस करें ना।
बिल्कुल,
या तो आप ये आर्गुमेंट पेश ना करें। जब आप ये पेश करते हैं ये बहस सामने या एक मफरूजा करते हैं कि इट इज एज गिवन, तो मैं ये नहीं मानता हूँ। या तो क्या मैं ये वापस लेता हूँ ये बात को। आप कहते हैं कि पार्लियामान सिर्फ वो काम कर सकती है जो 142 फेडरल लेजिस्लेटिव लिस्ट या एक्सप्रेसली या इम्प्लाइडली हो, उसके अलावा कुछ नहीं कर सकती। या तो कहीं मैं इस बात को वापस लेता हूँ। अगर आप इस बात खड़े हुए हैं तो मेरे सवाल का जवाब दीजिए। आप जवाब नहीं देते हैं, आप कहते हैं मैरीलैंड वर्सेस उसमें देख लें, उसको कम क्यों देखें?
माय लॉर्ड, मैं स्पेस टेक्नोलॉजी के बारे में तो केस तैयार करके नहीं आया नहीं जी, मैं तो प्रैक्टिस एंड प्रोसीजर पे हूं, उस पे मैं सवाल
उस पे बात करें ना। फिर आप ये ब्रॉड स्ट्रोक्स ना पेंट कीजिए।
स्टार्टिंग पॉइंट तो मैं आपसे कहीं से
आप ब्रॉड स्ट्रोक्स जब पेंट करते हैं अपने लिए मसले खड़े कर देते हैं, तो आप फोकस्ड रहें इसी बात पे।
मैं तो 142 जी
लर्नड काउंसिल यहाँ लर्नड काउंसिल आप आइटम 58 देखेंगे जी, आइटम 58 और दूसरा मुझे सिर्फ ये बता दीजिएगा, notwithstanding आर्टिकल 191, आपका आर्ग्यूमेंट ये है कि the parliament is bereft of jurisdiction to legislate in the context of any of the fundamental rights or access to justice.
My lord, I have not articulated my argument as yet.
अगर आप कर लें, I think बेहतर होगा अगर आप
argue as you want. Please go back to your. I apologize. You argue as you want.
Your lordship should not apologize.
चलिए करिए.
My lord, for 2 days I have heard all our questions.
करिए.
Let me address those questions. This is what I'm saying. Yes. My lord, I will answer your lordship's question also.
अब आप कर लीजिए ना.
My lord, the starting for legislative competence is entry article 142 or the body of the constitution. Now, body of the constitution for our present purposes, the only article relevant is article 191. In the legislative list, there is entry 55. Now, these are the two provisions that have to be interpreted and read. As I read, article 175(2), the expression subject to law, which is used in 191, is used in various other articles also. That by itself does not confer any legislative power or on any identified legislature. Just kindly look at Article 14. Article 14. 1-4.
Of man.
Dignity of man.
Article 14.
It says, the dignity of man and subject to law, the privacy of whom shall be inviolable. This by itself doesn't say who will make the law. The province will make the law or the federation will make the law. In order to determine who can make the law for the purposes of Article 14, you have to go to other provisions of the Constitution. The same is with respect my submission for Article 191 also. It does.
ये आर्ग्यूमेंट आप पूरा तो कर लें तो प्राइवेसी के मुतालिक कौन बना सकता है कानून?
मतलब फेडरेशन भी बना सकती है और प्रोविंस भी बना सकता है, दोनों बना सकते हैं. उनके लिए आपको देखना पड़ेगा कि लेजिस्लेटिव पावर स्प्रेड कैसे है, और दोनों ने बनाए हुए हैं, क्योंकि क्रिमिनल लॉ, पीनल लॉ पे
हो सकता है गलत बनाए हों,
प्रोविंस भी बना सकता है. और प्राइवेसी वगैरह के बारे में फॉर एग्जांपल इलेक्ट्रॉनिक क्राइम्स एक्ट है, फेडरेशन ने भी बनाया हुआ है.
नहीं, पर उसी तरह अगर चलें तो 191 में सब्जेक्ट टू लॉ है, एंड सपोज देयर इज नो, एंड आई थिंक देयर इजंट एनी कॉरेस्पॉन्डिंग एंट्री रिलेटिंग टू प्रैक्टिस एंड प्रोसीजर.
There is no.
So then the word law would become redundant in 191.
No, my lord.
How,
No,
what would
no,
it,
no,
what would
no.
happen to that?
That's exactly what I'm saying. I'm trying to proceed step by step. So 191, I read it, my lord, but the mere fact that the expression subject to law is used does not confer any legislative power, just as that it doesn't confer any legislative power under Article 14. What it is, my lord, the power is conferred on the Supreme Court. The power is on the Supreme Court to make rules. Subject to law is a limitation on that. It's a limitation on the power that has been granted to the Supreme Court. My lord, there are two Supreme Court judgments which say that, my lord, your lordship, I've mentioned them in my, written submission.
Mr. Bhandari, do you mean that
judgment cite kar
The first
citation?
Mr. Bhandari, do you mean that before making rules there must be some law?
My lord, I'm not saying that. There may be.
So subject to law, what does it mean, subject to law?
Well, and a validly enacted law by the appropriate legislature. It could be pre-existing, it could
Without any enactment, rule cannot be made.
no, rules can be made. They can
But
be.
subject to law.
My lord, the rule-making power is a standalone independent power on the Supreme Court.
But subject to law.
If there is a law, then the Parliament can make that law within the limits that I will just explain.
You said Parliament can make a law.
Parliament can, but I will just explain what in my humble understanding are the limits on that. I will explain that.
But there citations there.
Ji, my lord,
Mr. Bhandari, that is subject to Constitution and law. So you borrowed this power from the Constitution and subsequently you made rules.
yes, my lord.
This is the intent.
This is the intent. This is the intent. My lord, the citation is by Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My lord, this expression, subject to Constitution and law, was discussed in detail by Mr. Justice Kekaus in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739.
दूसरा कौन सा है?
2015 SCMR 1739.
ठीक है, ये phrase discussed हुआ है.
Tivana.
This phrase has been discussed.
This phrase, subject to the Constitution and the law.
कैसे किस नतीजे पे पहुंचे?
And they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the Constitution.
ठीक.
So that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the Constitution.
रेलेवेंट पेज बता दीजिए उसका कौन सा जजमेंट है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले का?
And Imrana Tivana का है जी 2015 SCMR 1739, paras 51 to 53 at 1764, 1765.
law development authority over T1.
اس والی law کی source پر کیا go ahead.
iski. So this by itself, I say. So you go back to 142, and there is no other provision in the body of the Constitution dealing with this. So my lord, you go back to 142. 142 takes you to entry 55. So let us see whether any
Entry
part.
55 is only related to the jurisdiction part.
My lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the constitution.
My lord, what?
ये जो आप अभी बता रहे हैं ना, इसमें तो subject to the constitution है, and law के ऊपर नहीं है, इसके ऊपर आप जो definition बता रहे हैं.
केकआउट साहब ने specifically subject to constitution and law भी discuss किया.
Judgment है ना, ये LDA का जो judgment है इमरान टिवाना का.
नहीं सर, आप वाला देखिए, केकआउट साहब की.
52, the only word subject to the constitution.
No sir, ये जो 65 सुप्रीम कोर्ट है उसमें दोनों डिस्कस.
It is referring the article 142. उसमें तो शब्द लफ्ज़ ही शुरू में
वो
इंट्रोडक्टरी
तो
है.
सब्जेक्ट
तो बताया subject to constitution.
जी, बट जो 65 सुप्रीम कोर्ट है उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया है.
इसका जो 65 का है, कौन सा है पेज?
623 at 633.
जरा इसको पढ़ लें.
65 अगर आप देख लें सर.
यस
जी, माय लॉर्ड, at 633.
ये भी subject to this constitution ही है, law नहीं है इसके अंदर.
सर है जी, आप देख लें.
पेज आप बता रहे हैं उसमें तो नहीं मिल रहा है.
आप यहाँ से
You are referring page 633.
ये सर मैं नीचे से 11th 12th line from the bottom at 633. The central legislature can legislate with respect to jurisdiction of courts, but the jurisdiction granted by Article 98 is subject only to this Constitution and not to this Constitution and the law. A reference to the various provisions
then my lord is correct.
आगे देख लेते हैं. A reference to the various provisions of the Constitution will show that whenever it uses only the word subject to this Constitution, it does not mean subject to this Constitution and the law. But whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution says so. So, when Constitution and the law...
So what? I'm not following.
My lord, what it is saying is...
Don't use your own words, use the words of the judgment.
This is that whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution.
It's not
begs the
enabling, it's
question.
not a power that is giving legislative competence.
Yes, that's what I'm saying. That
You have to go
then
back looking for the competence.
Yes, you have to go to the source of the power in the Constitution. And here the source of the power has to be in some other provision of the Constitution, which takes you to 142, and 142 takes you to entry 55.
Fair enough, but that's not coming out of this judgment.
Well, that is the only judgment on this that I put.
But this...
ठीक है, आपने मेहनत की, that's good.
But this is how I read this passage. Well, then let's go to entry 55.
You say that that law under 191 would stand through 55.
It can only stand through 55.
Only through 55.
Only through 55. Your lordship has-
एक सेकंड ठहर जाइए. Why not 55 read with 59?
But these are 59.
No, the 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा, my understanding is I may be subject to correction. It may specifically be mentioned there, but it can expand. If otherwise 59 is redundant, so then ancillary matters, incidental or ancillary matters can be added on to. So every provision, every item should be read with 59.
Absolutely.
ठीक है. अच्छा,
Absolutely.
एक second. Incidentally, you mentioned privacy, and I was just going through the list. I don't come across that word in the fourth schedule. Please correct me if I'm wrong.
Well,
You said the Federation can make law. You started with Article 14 and privacy you mentioned.
My lord.
But the cursory examination of the fourth schedule does not throw up the word privacy.
it doesn't, my lord, but there
No,
are,
but you said then both the Federation can make laws.
and it has.
No, it has. Can it still be unconstitutional? But in the argument, you should forget if it has. this they have also made a law, so that's neither is here nor there. But if the word is not mentioned, then your argument should have been that only the province can make the law.
Well,
Please enlighten me.
My lord, the parliament has, for example, the legislative competence to enact laws about companies. Now, in exercise about companies.
No, Bazari sahab, no, please don't do this. No, don't do this.
Make an argument.
You use the word, you chose the word of all the thousands of words circulating in the universe, privacy. You chose Article 14. Either you take back that argument or entrench that argument with some legal argument.
That's what I'm trying to do.
आप companies पे चले गए.
मैं company से example आपको समझाऊंगा जी.
Learned counsel,
let me answer this question.
इसको formulate कर दो. आपने जिस तरह कहा कि कानून बनाने का है Article 14, regardless of and notwithstanding Article 191, say a law is validly and competently made by the legislature. What if that law is in conflict with the rules made by the Supreme Court under Article 191? How will you read subject to law? Will the rules prevail or that law?
I will come to that, but let me answer my Lord the Chief Justice's question. My Lord, in exercise of power granted by entry 31, the company law is there. Now, the company law contains elaborate provisions which deal with the question of privacy of businesses, their premises. It deals with when search and seizure can be made, documents can be...
Take the point.
So, similarly, because criminal law is on the concurrent list under entry 1,
make
Article
the point
142.
about privacy.
Therefore, the province has also made laws which affect the concept of privacy. Well, privacy alone, privacy can very well be a standalone subject matter of a statute. It is a concept which can...
Federal or provincial?
Both.
Okay,
you made your point. If you could come back to the...
It can be both.
You made your point.
My Lord.
We've noted your point.
Lord.
If you could come back to entry 55.
Entry 55. Let's read it, my Lord. Jurisdiction, and it has two parts. The first part, and my Lord, what the Honorable Chief Justice said about entry 59 is exactly my case, and I'll explain why. The first part of entry 55, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. So this doesn't apply to the Supreme Court. And to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and conferring thereon of supplemental powers. Once this is invoked, then, as my Lord the Chief Justice said, matters ancillary or incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution.
But you're missing out the earlier words, as is expressly authorized by or under the Constitution. No, just wait a minute.
Well,
where is 184.3 expressly authorized?
It is not.
It is. 184.3 is in the Constitution.
But there is...
You're not hearing the point. The extent as is expressly authorized by or under the Constitution. 184th part of में दिया हुआ है ना आइन ने. हमें बस खुद से तो नहीं आया ना. दिया हुआ है आइन ने. ठीक है? The enlargement jurisdiction of the Supreme Court. Now the question is that 184.3 power that is already given to us. The Constitution could have not given that power to us. It is not an inherent power of the nature as under Section 9 of the Civil Procedure Code. Correct?
My Lord.
It's an extraordinary power which is rarely given in any constitution in the world.
Correct, man.
Correct? So
Correct.
far we are good.
Correct.
So that power was given by the Constitution to us. Now, are they giving an forum therein, enlarging the power or taking away the power?
My Lord, twofold answer. They are taking away the power.
How?
By, and I rely on the judgment.
Judgments को छोड़िए ना, आप arguments दीजिए ना अपने.
मैं arguments precedent की base पे दूँगा.
अपने हम no contention note कर लेंगे आपके.
it is a curtailment of power because the concept of finality attaches to judgments under Article 184(3).
But that's a different concept. देखिए, for instance, a 3-member bench decides something. Naturally, a 3-member bench cannot undo it. 5-member bench हो गई या whatever, full court हो गया. तो 184(3) की उन्होंने enlarge कर दिया power. ठीक है? I'm trying to wrap my head around the fact that you keep saying that it's taking away the power. The first power was conferred by Parliament through the Constitution. That power is being enlarged. If this power was given to, for instance, the Senate of Pakistan, okay, you will sit in appeal over 184(3) because Supreme Court can't sit in appeal over its own orders. So then maybe, yes, you're absolutely correct. But this power, it has not gone out of this building. It remains within the building. And unless you say 2 minds are always better than 5, that ends the story. But, you know, so you're saying that more minds would actually be destructive of the 184 inherent power if they think about something, or with the passage of time they may want to revisit things or maybe want to appeal things. I mean, you know, one thing is, of course, you can revisit something. ठीक है, वो तो एक अलग बात हो जाती है, वो तो revisit आप करते रहें, फिर वो देखें number of the judges count होगा, ये होगा, वगैरह होगा. बट ये तो एक स्पेसिफिक पावर दिया रहा है. इसमें मुझे समझ नहीं आ रही है, मेरे पावर क्या सुप्रीम, मेरे तो पावर्स कम हैं, सुप्रीम कोर्ट के पावर्स बढ़ रहे हैं, तो इसमें आप कैसे कह रहे हैं कि कम हो रहे हैं? ये जरा समझाइए मुझे.
My lord, as I said, I am as a counsel of this court bound by the law that your lordships lay down in precedents.
No, sorry to say, this is, आप मुझे कोई चीज बता दें, you as a counsel are first and foremost bound by the Constitution of Pakistan and the laws of Pakistan. फिर उसके बाद प्रेसिडेंट आएगा. प्रेसिडेंट आप लोग सब पहले आइन और उसको छोड़ दीजिए, वो बाद में आता है. पहले आएगा आइन, फिर आएगा लॉ, फिर आएगा प्रेसिडेंट. ठीक है? सुप्रीम courts, if they've been making laws, I think that's wrong. Their power is to interpret law. If a law violates some constitutional provision, strike it down. Now, we cannot assume power. I have not taken an oath to uphold the judgments of the Supreme Court. I've taken an oath to uphold the Constitution and the law of Pakistan until such time that law is violative of a fundamental right or whatever you want to argue, even the whole scheme of legislative scheme that has been laid out. I'm not bound by precedents. If that was the case, I would not have taken oath even as a judge, if I'm bound by all the precedents of the Supreme Court. Even dissent, even if the whole court says, I can still maintain I don't agree, but it will still be binding on me. That's a different thing. 189 says it will still be binding on me, but I can say I disagree. Otherwise, you kill dissent also. Then everybody has to agree to everything else. So don't just, these are important questions. You're just sort of saying that your powers have been taken away. I don't feel they've been taken away.
Before you, if you could explain the entry 55 again, I haven't got it. General usme bata de.
My lord, entry 55 allows, number one, only the enlargement of jurisdiction of the Supreme Court, and only where there is express authorization to that effect in the Constitution, by the Constitution or under the Constitution.
Enlargement का क्या मतलब है? How do you understand enlargement?
Enlargement, for me, as a matter of plain English, means something exists and you make it bigger. As again, my lord, with all
doesn't your argument.
My lord, let me articulate. The word enlargement, what enlargement means in the context of entry 55, and what enlargement means in the context of entry 55 has been interpreted by this honorable court.
Learned counsel, zara mere samjhne ke liye, there can be two situations. One, 184(3) ना होता और सिर्फ एक अपील दे दी जाती. Now here 184(3) jurisdiction already exists. A remedy is being provided. So there's a distinction between these two situations. The jurisdiction already exists.
My lord, I'll come to that.
An appeal is a substantive right. It has to be substantively given by substantive provision in the Act or the Constitution. You cannot by implication or by rules or by subordinate legislation create a right. 184(3) is a jurisdiction in itself, the original jurisdiction. For 50 years it has existed as such. Why do you think even the dictators or even the legislative assemblies which amended the constitution did not legislate on the one hand or amend the constitution on the other, and why has it all of a sudden now been done? Under what circumstances?
Yeah, Learned Counsel, Learned Counsel, I think there's a...
Mr. Bandari, you are in a very unenviable position.
Learned Counsel...
I sympathize with you. I sympathize.
I can assure that many of your lordship's questions might be answered, and I can't say will be answered, only if I'm allowed to articulate my
Counsel, I think...
I can assure, my lord, if your lordship can just allow me to articulate my submissions.
बहुत अच्छा question इन्होंने raise किया है. I think that is also to be seen in historical context. There were only 2 judgments of this court. This constitution was promulgated. Darshan Masih case and Benazir Bhutto's case. Regrettably, this court, after 2010, departed from both those judgments. And the manner in which 184.3 in many cases was used, that probably is one reason why the parliament, a representative body, wanted or needed to have these remedies.
My lord,
if you can go back to entry 55.
I'll go back to entry 55. But just as a brief riposte to that, my lord, 2 wrongs don't make a right. If this court was wrong, then the parliament is wrong now, and 2 wrongs will not make a right. And I'll come back to that. My lord, I'll come back to that. Let me go back to entry 55.
So going back to entry 55, can I be your voice on the bench
my lord,
and help
I'll
you?
be so grateful.
So what you're trying to say, just to support you and so that nobody sort of... So what you're trying to say is that entry 55 says that there has to be express authorization within the constitution for enlargement of jurisdiction. And one prime example, just as Asha had asked a question, prime example is 185.3, which says specifically that you can enlarge the monetary jurisdiction of the Supreme Court. So that is the express provision mentioned. Isn't that the...
My lord.
So my question then is that if this is what you're saying that it is purely to, there has to be express provision in the Constitution, even though I don't understand the under the Constitution, but anyway, let's stick to the by the Constitution. And example would be 185, and perhaps there are some other provisions which would give that express.
I'll come to that.
But my problem with this is that when we talk about enhancement of jurisdiction, I see that, but I have a problem with the practice and procedure part. That practice and procedure doesn't really flow out of 55. And that kind of makes the word law then redundant in 191, because that law is not finding any support. Even if we say 191 is not enabling provision, then that law must stand alone, must draw some power from the competence from some source. It's not coming out of 55, because it is purely for enlargement of jurisdiction.
Well, if 55 is rightly invoked, then practice and procedure will come in through entry 59. That, my lord, the Chief Justice.
But 59 reads that it has to be read along with the substantive part of it, which is enhancement of jurisdiction. So enhancement of jurisdiction is related.
Let me give. There are, to my humble knowledge, there used to be one very clear provision, was Zain Wali Constitution dena, regarding enlargement of jurisdiction, and which was actually taken notice of by this court in Baz Muhammad Kakar's case. This was, my lord, before its repeal, this was Article 247, Clause 7.
इसका पेज 970 पे पढ़िए ना जरा, ये पैराग्राफ पढ़ दीजिए, इसमें बहुत सारी चीजें बाज मोहम्मद काकड़ वाले केस के अंदर हैं जी. पेज 970 पे पढ़िए. As it has been pointed out, इसमें तो इन्होंने सपोर्ट किया है कि जो है जुरिस्डिक्शन को बढ़ाना हो, सप्लीमेंटल करना हो तो कर सकती है.
वो रिपील हो गया ना 247 जो
नहीं, आप कौन सा कह रहे हैं?
हो गया, बट द जजमेंट इज देयर. सुप्रीम कोर्ट का अपना जजमेंट तो है ना, वो रिपील.
Para 37 of Baz Muhammad Kakar. If I can just read this out, Article 247, Clause 7. As now it's been,
page.
Well, this is the Constitution itself. This was prior to its repeal.
No, Baz Muhammad Kakar ka page kaun sa?
Page 967, Para 37.
Citation.
This is PLD 2012 Supreme Court, 923, Para 37 at 967. This is one example of enlargement of jurisdiction of the Supreme Court in terms of Article 247, Clause 7, which read, my lord, neither the Supreme Court nor a High Court shall exercise any jurisdiction under the Constitution in relation to a tribal area unless Majlis-e-Shura, Parliament by law otherwise provides. And pursuant to this, an act was promulgated in 1973. And this was taken notice of by this honorable court in. My lord, that's one example. The other is, as your lordship mentioned, Article 185 Constitution.
185.3 is very
185 2D and E.
2, 3, Sorry,
These are
D,
express authorizations by the
185
Constitution.
2D, yes.
185 2D and also E.
नहीं, ये पेज 970 पे सप्लीमेंटल पावर का भी जिक्र है. पेज 970 पे जो पैराग्राफ है ना, वो आप पढ़िए, वो डिटेल में है.
जी जी.
उसमें ये क्लैरिटी आ जाती है. As it has been pointed out here and above.
My question is that even for a minute, I mean just something that if we were to leave 55 for a minute, what is really I mean, it's a question of interpretation. What's really stopping us from interpreting 191 to mean that it actually is envisaging a law for practice and procedure? It is the enabling provision. Suppose if we go in that direction, what comes in our way? I mean, that sort of solves a lot of mystery also. It is saying that the Constitution is envisaging that the Constitution could provide for practice and procedure, some law could provide for practice and procedure, and the Supreme Court can its rules provide for procedure. Meaning by, one way of looking at it is, meaning by that the Constitution is saying that, yes, for the purposes of practice and procedure, there will be a law. So 191 could be read as an enabling provision. If that is read as an enabling provision, then it sort of solves...
My lord, with all due respect, in my opinion, it can't be read as an enabling provision. It is a limitation, and the limitation that it imposes on the Supreme Court's power is not limited to practice and procedure.
No, but
let me just finish. Supposing the Supreme Court rules cannot say that in adjudicating our appeals regarding contractual issues, we will not take into account the contract.
My problem is that suppose there were no rules made by the Supreme Court. So how would we look at 191 then? And then there is a law, the word law is mentioned. Suppose it's a total green field, there's nothing in the... So then a law could be there to regulate the practice and procedure. If the Supreme Court decides not to make the rules for a minute, then the source could be law.
My lord,
so then to call it limiting would be not...
My lord, could it be provincial law also? The law will
considering that it relates to, I mean, that's another issue with entry 58, that what does relate to federation mean? So if it relates to federation, perhaps it's a federal law that we're talking about or not. That's another question that I want to ask.
The problem, as I said, there is a structural limitation on the word law in Article 191. You can't read it. Shoresh Kashmiri's case, PLD 69, Supreme Court 14 said, law is very broad. But here you will not include provincial law. You will, in my humble opinion, you will not include ordinances because ordinances are executive acts. If you allow, if I can just finish this, if you allow ordinances and rules which are law to be read into law in Article 1, what happens to 175.3? Judiciary has to be separate from the executive. How can you allow the executive to make rules for practice and procedure of the Supreme Court? So the word law in 191 has inbuilt limitations. I concede that it will include Act of Parliament, but in certain limited circumstances. Only when entry 55's conditions are met.
So your answer to the issue is you would come through 55, you would come up with a law relating to enhancement, which is explicitly provided, and in that law, you could then ancillary provide for practice and procedure.
That's my reading.
That's the only way to get
That's the only way you can.
But then those provisions would relate to the enlargement part, not anything more than that.
Not anything. And that's why I say it's a very restricted power. My lord, sorry.
In terms of you raise a very interesting way to look at this thing, but I think if we look at law as as conferring an enabling jurisdiction. I think one issue with 191 is that we have on the same thing, namely the practice and procedure of the court, we have two law-making powers. One is the Supreme Court. It's a direct grant by the Constitution. And if law is read in an enabling sense, then Parliament also. So this creates a situation where on the same subject matter, if I may use that term, ordinarily the problem arises where on the same subject matter, the division in terms of law-making ability is between federation and the provinces. Right? So to take a very simple example, entry 49 of the taxes on income other than agricultural income, right? So the subject matter is tax on income. And the Constitution splits it into two. Agricultural income goes to the provinces, this goes to the, and we have all issues of trespass, that, and you know all of that. But here the interesting thing is that on the same subject matter, practice and procedure, you have the Constitution is giving a grant to the Supreme Court itself. If law is read as an enabling power in Article 191, then the same power is conferred on a separate branch, the legislative branch. So, in terms of the principle of separation of powers, how do we resolve, how would we resolve a conflict if law over there is to be read as an enabling power? In terms of legislative competence, the division between federation and provinces, we know all of that. Here, how would we draw the distinction? How would we resolve a conflict? So maybe, because speaking for myself, I am not too satisfied with you, the way you are identifying it with entry number 55. Seems to me that a more natural on your reading would be entry 58. But that would mean that it is not an enabling provision. It doesn't really, it allows them to restrict. Otherwise, the conflict between two separate branches, making something that is law on the same subject matter, how would that be resolved?
My Lord, I will address that.
Yeah, I think that's an excellent question. You want to mull it over. We will reconvene after lunch or prayers. ठीक है तो आप आधे घंटे में वापस आ जाते हैं ठीक है you can mull it over the question before you start. We don't want to cut you short and you start something it doesn't finish.
ठीक सर ठीक है I'm grateful जी grateful.